Well, good afternoon, everybody. Welcome to our webinar this afternoon. My name is Louise Turner and I'm the Membership Development Manager here at CILEx. So today we're going to talk all about how you can become an advocate and how you can get the rights to represent your clients in court. So as you can see, the webinar is being delivered live, which means that you can ask questions as we go along. So I just want to take a few moments now so that you can familiarise yourselves with the Q&A box. So if you hover your mouse over the middle of the screen, slightly towards the bottom, a toolbar will come up and you'll see in there's two little speech bubbles. One has a question mark in. If you click on there, then the Q&A box will appear on the right-hand side of your screen. So please use that box to ask any questions you like of our presenters today. We've got Danielle Ingle joining us from CILEx Regulation and Roy Morgan from Altior by Barbri. So our presenters might also use that question box to ask you questions. So make sure that you've got it visible on your screens now so that you can use it. All of our slides from our webinars are circulated afterwards, and we also will circulate the Q&A. So we try to work through your questions as we go during the webinars, or find a convenient time, usually towards the end, to go through some of your questions. But if we don't get to answer all of them during the webinar, don't worry, because we will answer them and we'll circulate them all afterwards with the slides. So this week's webinar is quite close to my heart because in 2011 I was authorised by CILEx Regulation as a Chartered Legal Executive Advocate in criminal proceedings. I would say this was a real gear change in my career because it allowed me to gain parity with my colleagues who were advocates in the office who were already going to court. It also allowed me to offer continuity to my clients in their representation and enabled me really to build up my client following. So it was a really positive experience for me to do the advocacy course. 2 years on from becoming a CILEx advocate, I then completed the Law Society Criminal Litigation Scheme. And in 2013, I was authorised to act as a duty advocate within my local magistrates' courts and police stations. So that was really valuable to the firm that I was working for, and it also afforded me a nice pay rise, which I was very grateful for, and it was good because I put in a lot of hard work and dedication, so I was really happy with that. But most of all, happy that I could represent my clients in court. So that was a real, a real achievement for me. So today is all about exploring how you too can become authorised as a CILEx advocate. And I'm now going to hand over to my colleague Danielle Ingle, who is Practitioner Team Leader from CILEx Regulation, and she's going to discuss with you the route to becoming authorised by CILEx Regulation as an advocate. So welcome to Danielle.
Thanks, Louise. So as Louise mentioned, I'm the Practitioner Team Leader at CILEx Regulation, and one of my responsibilities personally for that is undertaking the work that we do in relation to authorising CILEx practitioners and Chartered Legal Executive Advocates. I'm going to go through the stages of the process of becoming an advocate today using the Rights of Audience scheme. We do offer the opportunity to become an advocate with litigation rights as well under the Independent Practice Rights scheme. I might touch on that as we go, but I think we might be planning to do a webinar on practice rights separately. So if you've got questions about that, I'll talk you through later in the slides how you can mention those to us. So then if we move on to the next slide and look at the route. So essentially, there's 4 main steps that you need to cover when you're coming to CILEx Regulation looking for authorisation as an advocate. This is that you've got a matched law and practice paper at level 6 or equivalent. You then apply for a certificate of eligibility, attend an accredited advocacy skills course, and once you're a fellow and you've done all the above steps, you can apply to become an advocate. So if we look at moving on to seeing about completion of the relevant units, if we move to the next slide, You can see, as Louise mentioned, that you can apply for rights in 3 main areas: civil proceedings, criminal proceedings, and family. Now, there are requirements in the Rights of Audience Certification rules that the applicants are graduate members of CILEx or chartered legal executives, and that they have relevant knowledge to the area that they're seeking the rights. So at level 6 standard, if you're looking for a civil proceedings certificate, you would need to have covered contract law, law of tort, and civil litigation. For criminal, you'd need to have covered criminal law and criminal litigation. And for family, family law and family practice. Now, if you've come to CILEx with exemptions, maybe a law degree and then you've done the graduate fast track, or you've done a law degree and then a postgraduate qualification like the legal practice course or the bar training course, you can look at using those exemptions for this. If you haven't covered these when you did your exams, if say you did your exams in a different area and you've spent a lot of years in practice doing criminal, but you did your exams in family, this scheme probably isn't the right one for you, and this is where practice rights might be better suited. You can demonstrate the knowledge that you've gained through practice for that application scheme, whereas this one's slightly more rigid. So it's probably best, if you are concerned about the academic side of things, to get in contact with us at applications@cilexregulation.org.uk, and I'll be happy to talk you through the requirements of the other scheme. So I think that covers this slide, and if we move on to the application for a certificate of eligibility, there are some other eligibility criteria other than just your membership status, which obviously you need to be a graduate member or already authorised as a chartered legal executive. You also need to make sure that you're employed in the right sort of circumstances. So this scheme isn't open to someone who's self-employed. You need to be employed by an organisation that's able to provide litigation services, or you're employed and you're supervised by someone who's authorised to conduct litigation. That would generally be an authorised person like a CILEx litigator or a solicitor, or potentially a barrister with extended litigation rights. Once you feel like you're comfortable with that criteria, and I would suggest just having a quick look at the rules, you can start to make your application. The application covers off your work history, your experience, a bit about your employment, because obviously that's part of the criteria for eligibility. And we also ask your employer to sign the application to confirm what you've said, and also to confirm that you have the right exposure to the work and would continue to do so if you were authorised as an advocate. So the application form can be found on the CILEx Regulation website, as can the relevant portfolio templates that I'm going to talk through in a moment. But essentially you're putting together an application form and then a set of case studies. So this is where the points on the 5 litigation and the 3 advocacy/police station comes in. So this application is really looking to see that you've had the right exposure to work, that you would be able to cope with the demands of the course, and you'd be ready to go into court. That doesn't mean that you're overly confident, but just that you've had a bit of experience, you've got the right level of knowledge, you understand the procedure and the rules that you need to follow for going into court and representing your clients there. So the 5 litigation portfolios, there is a specific template for litigation portfolios. It can be found on the CILEx Regulation website, but equally you can email us and we're happy to send it through. And this goes through the assessment criteria for litigation. And when we say litigation, we mean casework that you're handling from instruction to the point where you may have to instruct someone else to do the advocacy, or it's settled before court. It's the casework side of what you're probably doing if you're already working in these areas. The 3 advocacy and police station advice cases. So with civil and family applicants, it's quite common that you might be using some of the exemptions under the Legal Services Act to do some level of advocacy. So for these, you would pick 3 situations where you've undertaken advocacy and you talk through how it went. We ask you to talk about what you were instructed to do, where it took place, the evidence that you had to consider, and also to evaluate how you think you did. With criminal applicants, we understand that there's some restrictions that mean it's really difficult to get court experience before you've been authorised as an advocate. But we do recognise that a lot of CILEx members do have the accreditation to provide advice at the police station. So in place of choosing 3 court advocacy examples, we'd say choose 3 where you've given advice at the police station. So you may have taken the call, you go down to the station, you then tell us what's happened, why a client's been arrested, and it may be you then take that client right through from the police station and through to the point where they go to trial, and then you can't represent them, which was a point that Louise mentioned a few weeks ago was one of the reasons why she was driven to do the advocacy qualification. But equally, it might just be that you just cover the police station part and refer it on to a colleague. So you've got some options there. Again, as I say, those portfolio templates, there's specific ones for litigation, civil and family advocacy, criminal advocacy and police station advice. So just make sure that you've got the right one. If you've got any concerns, email us and we can make sure that we send the right ones over. Another part of the application is that you can provide details of 2 authorised persons who can act as referees to support the application. Now, the stipulation for this is that you cannot use your employer, former employer, or a co-employee as a referee. Lots of people then question, okay, so who can I use? So a lot of applicants recently have been using opposing solicitors or lawyers, barristers that they've instructed to undertake the advocacy, because in the in the reference, we're asking the referee to comment on your knowledge, your preparation, your understanding of the law, which those sorts of people can comment on quite comfortably, and they don't have that. They have a much more independent relationship to you. With civil and family applicants, we do recommend that one of the referees is a member of the judiciary. So we do quite often see deputy district judges or district judges acting as referees for those applicants. With a criminal applicant, obviously we don't expect the same, because the chances are you're not going to have that same opportunity to be in front of a judge before this. There is an application fee for the assessment of the certificate of eligibility side of things. It's £110. That's paid to CILEx Regulation. In addition to the assessment fee, there's also a requirement to do a standard DBS check. The fee for that is around £35, and that's paid to the provider of the check. And then obviously there are course fees to consider that are paid to the course provider, and the fee for the course that Roy's going to be talking about is around £2,000. So that's the bare bones of the application. If we move on to the next slide. So how is that processed once it gets to CILEx Regulation? So one of the big things that lots of people worry about is, if I've got it wrong, do you just fail it and that's it? And the answer to that is no. Like everything that CILEx Regulation do, we're assessors and it's an assessment process. So unlike an exam, we work with you. We can't obviously tell you what to do, but we can guide you into what the standard is. And sometimes it's just that you need. So when you first send your application in to us, I will take a look at it and review the presentation of the information and look at if there's any specific areas that need to be expanded. And I am going to move on in a bit and talk about some of the areas that commonly people fall down on. And we work together to get the application ready for assessment. The assessment in the rules is required to be undertaken by an external advisor. So we have 2 advisors currently who are specialists for criminal, civil and family proceedings, and they will review the application in full and let us know if they consider that it demonstrates sufficient competence. Again, the assessor might ask for additional work. This isn't anything to be put off by. Sometimes they want extra explanation. Sometimes it's a case of they're worried about the range of the work, so they might ask some further questions about that. And more recently, we've had just, can I see another example of a police station advice portfolio? It's all perfectly normal. It's nothing to be put off by. It's just they want to gauge and be comfortable that you're going to be able to do the best in the course when you get to it, rather than being sent too early. Once we've got through the assessment side of the application and the processing of that, we contact your referees, we review what they tell us, and that's one part of obviously the checking. And as I mentioned before, there's a standard DBS check requirement. We talk you through all of that when you apply. The reason for that is because technically you're applying for additional rights, additional practice rights in terms of rights of audience. So there is a requirement for a check there. There is a need for some ID to be sent to us, but as I say, I won't bore you with the details of that today. It's really straightforward and we'll talk you through once you've made your application. So if we move on to the next slide, I think we're looking at top tips for your portfolio. So as I mentioned before, I look at every application when it first comes in. So I've got a reasonable wealth of knowledge as to where people struggle and how people can benefit, hopefully from my 5 years of knowledge of doing it. So first thing I would certainly say is choose a range of cases. So in the past, applicants have chosen very similar crimes, family disputes, civil issues that don't necessarily reflect their full workload. Not everyone does every case exactly the same, and it's best, because you've only got to choose 8 and you've got a 2-year period to do that from, choose a range, you know, a different type of offence, a different type of family problem, just so that you can show your exposure to different things. Obviously, in family proceedings, quite a lot of the time, people will be dealing with children disputes. If that's all you do, then that's all you can obviously demonstrate, but maybe mention in other parts of your application about your knowledge and your awareness of things like family finances or domestic violence or something like that, just so that you show that you've got that readiness. The course will cover a range of different issues, so if you look like you might not be prepared for it, it's something that the assessor's likely to comment on. My next top tip would be using plain English and doing it as if you're speaking to your client about what happened, or you're speaking to a friend in a restaurant about what happened. So make sure that you explain the law fully. There's specialists that are marking it, but at the same time, don't assume that they know. So recently in some family applications, we've had people mentioning threshold criteria and then not explaining what it was, or just saying it was a theft offence. Well, how are we knowing that there was actually a case to answer or not? So make sure that you cite the law and explain it and apply it. Don't just take a shortcut because you think, oh, well, it's being marked by a fellow lawyer, so they'll know. The next point is issues doesn't always mean problems. Now, the reason I've put that here is if you've looked at the portfolio template, or if you're going to look at the portfolio template, a lot of it comments on explain the evidential issues, explain the conduct issues. And lots of people just end up saying there weren't any because they think, what were the problems? And actually, we're not meaning problems here, we're meaning things to consider. So with evidential issues, think about what the evidence was in the case. What's the strengths of that? What's the weaknesses? Does it support you? Does it not? And how are you going to deal with it? If there's a gap, why? What do you need to know? That sort of thing. Be reflective. So some of the template, it's very easy to just generalize what you did, advice that was given. Personalize it and reflect on what you did. Reflect on how you advised them, the decisions that you had to make, but actually what they were, rather than just saying we had to make a decision regarding X. Why? What was the decision? Was the client happy with it? Did they need to have it explained to them? That sort of thing. And the other big tip that I would give is future training needs. So obviously you've got to a point in your career now, if you're thinking about applying for advocacy rights, where you're fairly confident in what you're doing and you're not seeing things for the first time every time. That being said, the portfolio templates ask you to comment on your training and development needs. Now, where you've dealt with something 10 times before, you may not have a specific training or development need from that issue. I understand that. Having said that, you will have done things in the past to prepare you for that moment. And equally, there's things that you'll need to do in the future to keep you up to date. So whether you think about the things in the past that have happened or the future CPD that you may need to undertake, don't just say there weren't any training needs, because the assessors really aren't keen on that. You're trying to progress yourself with this application. The course is part of your training, obviously, for becoming an advocate, but it doesn't end there. I'm sure Roy would hopefully agree with me that it doesn't end there, and there are other things that you need to consider to remain as good and as competent as you can. So they would be my 5 top tips on the portfolio. If we move on, so I've mentioned about obviously the application. What happens next? So once we've dealt with the certificate of eligibility side of things, you would be issued with a certificate of eligibility and able to register on an advocacy skills course, which Roy's going to talk about, so I'm not going to labour the point on there. Once you've completed the course and it's all, hopefully you passed and it's all gone successfully, you will receive your results around 2 months after the course is finished. Once you've got your course results and you know if you've passed or not, if you've not passed, the course provider will allow you to resit in most occasions, so you can deal with that side with them. But once you have completed the course successfully, you can then come to CILEx Regulation and request an advocacy certificate. There is an advocacy certificate form that you do need to complete. It's very short, but it just allows us to just do some final checks before we do the authorisation. And once we've done that and you've obtained fellowship, if you applied when you were a graduate member, you'd be authorised as an advocate and ready to go into court. So that's really the full process. If we just move on to how to apply before I move on to Roy. So the certificate of eligibility application is really why you're going to be coming to CILEx Regulation for this. At the moment, due to the current restrictions, our offices are closed, so we're accepting online applications only, and the email address for the submissions is there, advocacy@cilexregulation.org.uk. Because of the offices being closed, we will invoice you on receipt of the application rather than you needing to send any payment information with the application. We're preferring payments by backs, but obviously we can take credit or debit card over the telephone as well. We'll do all the review. Generally, the application can be completed in 6 to 8 weeks. Sometimes it takes a bit longer if there's lots of requests for information, but 6 to 8 weeks is generally what we would recommend. And that's really it from me. If you've got any questions, obviously you can pop them in the Q&A. I'm going to start answering some now. But if you want some time to rethink about things and send us an email, that's absolutely fine. I'd recommend the advocacy email for your questions, but equally we do have applications at cilexregulation.org.uk if you're more familiar with that one. So that's really it from me. I hope that's explained what the process kind of is, and I'll move on and pass over to Roy so that he can tell you a bit more about the course.
Right, thank you, Danielle, and good afternoon everybody out there. Right, firstly, by way of introduction, there's a slide that just gives you a very brief CV of myself, so you know why I'm qualified to talk about the advocacy rights courses. I am a solicitor advocate, I have higher rights of audience, and I'm the lead advocate trainer for Barbri Altior. So I've been training advocates for the best part of 30 years, most of that time alongside running my own practice and spending most of my life on my feet in court. So I handle advocates at all levels, for trainee solicitors on the PSC course to higher court advocacy and many CPT courses. But most importantly, and close to my heart, I actually conduct the advocacy rights course for CILEx in the field of crime, and I'm also involved in part on the family advocacy rights course. And I also work with the other trainers who deliver our civil advocacy rights course. So the well, I think that's probably enough about me. I'd like to know something about you. So the next slide is actually poses a question of you. Now, I suspect that many of you have been involved in some form of advocacy, maybe with district judges, maybe with chambers applications and so on. But it'd be very helpful if we know something about the makeup of the audience. So perhaps you can just use the chat box. One word answers are fine, just to let us know what areas of law you're actually working in, whether it's crime, civil, family, employment, immigration. One word will do, and we'll just get a flavour for who's out there. But the reason you're here, I suspect, and the question you wanted to know is on my next slide, and that really is how you acquire these rights of audience. I'm sure he'd like them as well. But to answer that question, Mr. Trump, it falls into two parts. Once you've gone through the process that Danielle has just explained, you'll then attend the training course with us. It's 5 days together, fantastic course. We really get to know each other, and you really get to know a lot about advocacy. But it's split into two parts to acquire the higher rights qualification. There's a practical assessment and there's a written assessment. We train you to cover both of those. So my next slide is going to just introduce the sort of things that we cover during that training. It's 4 days of training, 1 day of assessment. So basically we equip you obviously to pass the assessment, but more importantly, we also equip you to use that qualification on your feet in court, and to walk into court, if not the next day, then as soon as you've gone through the administrative process, and to be able to handle whatever the court may throw at you. Most importantly, in acquiring those advocacy rights, you will have the same rights as solicitors who are conducting advocacy, but you will be better prepared. I train trainee solicitors, and among qualification, they have certain rights of audience. You will have those same rights of audience in whatever field you're working, but you receive much more detailed training and more time training just acquiring this qualification. So you will actually be better prepared. And I think that'll be even more so come next year when the solicitor qualifying exam kicks in, and they'll be receiving even less training than they do now. So you can really steal a march on some of your colleagues out there. So we cover everything in the training, from opening of the case to closing of the case, everything in between, and everything that may occur beforehand, and even some of the things that may happen afterwards. So it really does equip you to get through the assessment and to use those skills. And yeah, tucked away in the small print at the bottom, and of course, is the assessment, which we will get you through. So how do we deliver the training? My next slide will just give you the answer to that question. We have traditionally run this course face-to-face, as you will know, and that involves 4 days face-to-face training, and then the 5th day is a day of assessments, and I'll talk about those in a short while. But obviously, given the lockdown period, we haven't been able to deliver those courses face-to-face. So we are moving this course to a live online presentation and a live online participation. Perhaps I should just tell you a little bit about the live online story as far as Barbri Altior is concerned. Perhaps we can pop back a second, Tong, if you wouldn't mind. I mentioned some of the advocacy training that we do, and in March of this year, when lockdown kicked in, there were many trainee solicitors out there who were very worried about whether they would reach their qualification because they wouldn't be able to do the advocacy module, which is a 3-day course. So we ran a 3-day pilot, and we were able to convince the SRA that it could be run online, and we've now been running all our advocacy courses, including CPD courses that some of you may want to attend on in the future. Danielle mentioned about it isn't just getting this qualification, it's maintaining it and improving it. And we do quite a number of CPD courses, all of which are now being conducted online. And now the CILEx Advocacy Rights course, we're preparing that ready to deliver online. Now, I must confess, I was skeptical beforehand as to whether you really could train advocates online, and I've surprised myself because it's working. And the feedback we're getting from delegates on the live online advocacy courses is nothing but positive. They're having a really good experience. So the way in which we deliver it online, very similar to how we do it face-to-face. There's trainer presentations, there's preparation and participation by the delegates working in groups, and with the system we use, we can move you into breakout rooms, but just the same as walking down the corridor into another room where you then work within your group or within pairs, and you prepare for various practical exercises. So you spend a lot of time on your feet metaphorically speaking online, of course, actually conducting advocacy exercises. We also take you through, and you actually sit a mock written assessment, which will stand you in good stead for the actual assessments. So I'm going to use the criminal advocacy rights course that I take to give you a flavour of the structure of that course. Now, for civil and family, the content obviously is very different, but the structure is quite similar. So hopefully this will give you a flavour, and I will talk about civil and family once I finish this. So 4 days of training. The first day, and I'll just give you an indication on the first slide there, this really is dealing with every sort of application you may need to make on your first day in court. Your client's been arrested, appears before the magistrate's court. You may not be ready, the prosecution may not be ready. So you're having to deal with possible adjournments. Does the case stay in the magistrate's court? Does it go to the Crown Court? Allocation hearing? You'll have to deal with that on the first day. If there are multiple charges or multiple defendants, then you're dealing with joinder and severance. And of course, if it's going off for trial, there'll be case management or the equivalent of pre-trial review. And most importantly, for your clients who've been held in custody overnight, they want you to make a bail application. So the delegates practice all these sort of applications on day one. It's obviously a very full day, but firstly, very rewarding, and secondly, hopefully, very educational in terms of being able to stand on your feet on that first day in court. Day two, very different. It's my next slide, which is really a black letter law day, and this sets you up for normal practice, of course, but most importantly for that written assessment. And we cover all the areas of law that are likely to crop up during your written assessment, and you see the various subject matters there. And at the end of that day, you actually sit a mock trial, exactly the same as, a mock assessment, exactly the same format as you would for the actual written assessment. So that hopefully gives you enough of a steer to get you through your written assessment. But what is this thing called the TSP? Well, it's explained on my next slide. TSP stands for a trial strategy plan, and if you take nothing else away from this course when you come on it, the trial strategy plan is, I would predict, is the thing that you will use most. The most common feedback I get from delegates who've been on this course and many other courses, and I introduced the trial strategy plan to many other advocacy courses, it revolutionizes the way in which you prepare your case. And a similar structure, similar trial strategy plan method is used on the civil training course and also on the family training course. But I'm dealing with crime here, so just to give you a feel for it, and what do those 6 headings cover? The case theory is, what is the case about? What does the prosecution say happened? What does the defense say happened? And what that does is to start the feel for the case and how you're going to run it. Then move into case analysis, which is working out where the real issues are. And Danielle was talking about issues, and this is what we identify. What are the issues in this case? What is it the prosecution really need to prove? And in most criminal cases, 90% of the evidence is not in dispute. It's working through that 10% where the gems are, where the key issues are, and that's what you need to deal with. We then analyze our own evidence. We look at the strengths and the weakness of it, and those of you who've been conducting various cases in various fields, I'm sure, would have done a similar sort of thing, perhaps in your mind, but we formalize it in a much more detailed way. And then very significantly, the fourth point there, dealing with your opponent's evidence, we analyze each witness that the prosecution are going to call and assess the approach we take with those witnesses. Because you don't need to dive into every witness and attack them and rip out the jugular as you see on TV. Sometimes you need a much more softly approach, because many witnesses on the other side can actually do you a lot of good. So it's making that analysis, and this revolutionizes the word I used earlier on, the way in which you cross-examine, and you're preparing your cross-examinations way in advance of trial. And it gives you that comfort blanket. Of course, you'll fine-tune it as time goes on, but it gives you that comfort blanket ready to face the trial. And then we deal with admissibility, submissions, points of law that you may want to make, and also anticipating applications the other side might make, you want to resist. And then finally, point 6 there, lines of investigation and preparation. This is really akin to an advice on evidence. At day 1, your case is nowhere near trial ready. So what do you need to do to get it trial ready? And we look at that, and it again sets up your preparations at a very early stage. So that's day 2, again, a very full day, but it prepares you for practice, it prepares you for your assessments in quite a thorough way. And there's a lot, it's very interactive. each of these days throughout the 5 days. So day 3 on the next slide then is effectively the mock trial day. We run a trial, but with a big emphasis on cross-examination. Because what I find is, or most of the concerns I receive are about cross-examination. People are worried about cross-examination. It frightens some people, cross-examination. But there are tips and techniques that we can give you that can make it, I won't say makes it easy, but it makes it a little more comfortable to be able to handle confidently and competently. And people ask about golden rules. I'm not sure if there are golden rules, but there are tips and techniques, and I give you my top tips and techniques for being able to handle a good cross-examination. Some of them are quite surprising, but they just give you that extra edge to enable you to go into court and cross-examine your witness with confidence and with competence. Day 4 then, and each of these days is covering one of the elements of the assessment. Day 4 then deals with sentencing and mitigation. One of the first things that new advocates in the magistrates court have to deal with is a sentencing exercise. The majority of clients, believe it or not, in the magistrates court actually plead guilty, and they therefore need to be sentenced. And very often that's on the same first day they appear in court. So delegates need to be ready for that. So we conduct a series of sentencing exercises so they have the confidence to walk into court and be able to mitigate properly on behalf of the client, and hopefully avoid them being locked up, as is shown on the left-hand side, and have the freedom and liberty on the right-hand side. I have a little bit of concern over that, the photograph on the right. I took that from another course I teach. It's a time and stress management course, and it's meant to demonstrate freedom and liberty and being a free spirit and so on, until I suddenly realized it could also be seen to be somebody jumping over the edge of a cliff. So hopefully, if you can mitigate well enough, your client either won't be going in the cells and won't be jumping over cliffs. They'll be walking out with you and going home to enjoy the freedom of life. Day 5 then, of course, is the biggie, because that's the assessment day, and that's on the next slide. Now, you'll see there are 4 exercises that the delegates have to conduct for the assessment. There's something similar, obviously on a different scale for both civil and family, but for the criminal assessment, they conduct those 5 exercises on day 5. Now, they don't just come into the assessment room and do them one after the other. That would be unrealistic and would be quite a pressure. It's tiered. So however many delegates are being assessed that day, they will come in one after the other and conduct their bail application. They go back to a preparation room. They have time, or a breakout room as we're doing it online, and they have time to fine tune their preparation before they come back in, again, one after the other, to do their cross examinations, again, with a witness who also is online. And the same with either a speech, closing speech, or a legal submission, and again with a sentencing or mitigation exercise. So we will have covered every one of those elements, and the delegates coming in really have a competency and a confidence to be able to get through the assessment. And the pass rate actually is fantastically high. So that's basically how the 5 days for the criminal assessment works. There is a written assessment, of course, and I'll just sign that off now with the next slide, if I may. What's involved in the written assessment, and the next slide will just give us some headings to show that. It's what it says on the tin. It's dealing with evidence, dealing with the law, and dealing with ethical situations. And again, we cover those through the course, and it sets you up nicely for that written assessment. Now, whilst the 5-day training and the 5th day of the practical assessment is conducted usually within 1 week, the written assessment usually takes place the following Monday. And we have actually been doing that online for some time now, so there's nothing new about that. But just to explain that, it's a 75-minute assessment. You have 5, 6, 7 essay type questions, and you have 10 multiple choice questions. The pass mark actually is 50%. So given the training that we give you, hopefully you can sail through that on your written assessment day. So that's crime. That's a very brief outline of what the criminal course entails. As I say, it's a similar structure for the civil and family, but I'll just give you a brief outline of the family course on the next slide. Now, I have mixed feelings about using PowerPoint. It works well on some courses, not sure about some other courses, but I'm not a big fan of slides with a lot of writing on them. And there's no way around this, but to show you this slide with a lot of writing on it, to give you a flavour of what is covered in the advocacy rights course for family lawyers. And we cover all the ingredients you see down the left-hand side of that slide there, and even more. And that again prepares you in the same way as we do with the criminal advocacy rights course, prepares you to conduct both the written assessment and the practical assessment. The practical assessment for family obviously is slightly different from crime, but again, you will do 4 exercises. One is a case analysis or presentation of a skeleton argument. You'll make an interim application, as you would very frequently in the family court, of course, and then you conduct a piece of work with an advocate, with a witness who will be online. It might be an evidence in chief, it might be a cross-examination, it might be a re-examination based on an exchange of statements. And then finally, a speech of some sort, usually a closing speech. So 4 similar exercises. Again, we'll be conducting those online, and again, it works. Now, as far as civil is concerned, if we can see the next slide. Yeah, it's about that dirty stuff called money usually, isn't it? Which is why I try to stay out of the civil courts. I'd rather be dealing with people's liberty. There's an oddity with the civil course, because there is a part of the course you can take just for 2 days to acquire the rights to just deal with in-chambers applications, judges' room applications, and so on. But why would you do that? For 2 more days, you can actually get the full package and be able to stand on your feet in open court. So it's a similar 5-day course, 4 days of training, 1 day assessment, and you'll see there the sort of rights that will give you, even to appear in the coroner's court. And I think I can count on the fingers of one hand how many solicitors I know who have any experience of appearing in the coroner's court, who want to go in the coroner's court. But by acquiring this right, you would have the right to appear in that court as well as everywhere else. And the next slide then just shows the sort of assessment for civil, very similar to the families you'll see there. I won't go through it, you can see it for yourself. And as you know, this is recorded anyway, so you can always come back to it. But a very similar structure to both the family and the criminal advocacy rights course. So the next slide poses the question that I'm sometimes asked, why do it? Well, there's 5 answers there. We're in a strange time at the moment, aren't we? And I'm receiving lots of queries from lawyers who are furloughed at the moment, who are wondering really what their future might hold, who are wondering whether they can put themselves in a better position for their firms and for themselves. So career advancement and business development is a great opportunity to really acquire a very worthwhile and a valuable qualification. It's good PR for the firm, of course, it's good PR for you. But most importantly, perhaps for the clients, it's continuity. What an awkward conversation is it that when you perhaps, from a criminal point of view, you've been at the police station with the client, you've been preparing with them, you gain their trust, and then suddenly you have to say, I'm sorry, I can't do the hearing for you. You have to hand over to somebody else who has rights of audience to do that hearing. It's an awkward conversation. With the rights of audience that you can gain on this course, you don't need to have that awkward conversation. You have that continuity, and the clients who've warmed to you and whose trust you've developed, they get that continuity. It also is financially beneficial, of course, because you're keeping the fees in-house. You're not farming it out to counsel or solicitor advocate or wherever it might be. You're keeping those fees in-house. So it's good business. It puts you in a very good position and makes you even more of an asset than I'm sure you already are to your own firms. So finally, on my last slide, I smile before it even comes up. What are you waiting for? Despite the color of my hair, I have a 6-year-old daughter, and I tried to pick her up from school as frequently as I can. And I was picking her from school one day, and she was actually in their hall doing a martial arts course that she does, of all things. She can pack a good punch, I tell you. But while I was waiting, I was looking on the boards outside, and they're a big hockey school. It's grass hockey, not the ice hockey you see there. And I saw this expression, you will always miss the shot you never take. I think they've stolen that from the world of basketball, actually. But you'll always miss the shot you never take. And I've used that expression now in so many courses because I think you have a great opportunity, particularly at this time, to take that shot, go for it, and acquire your rights of audience in whatever direction you are going. So take the shot. Hopefully I'll see you on the course soon. Thank you very much.
Thank you, Roy. And thank you to Danielle also. Thank you both for those excellent presentations. I'm sure our members now feel fully informed about how they can get their advocacy rights. We've got a few minutes to go through some questions, if that's okay. And One question that really chimes with me, because this is what I was asking myself before I did the course, is how much experience should you have before taking part in the course? And I know I knew I had enough experience when I was down at the police station and I could give the custody sergeant a good run for his money on making representations for bail. But you know, how do you know, Roy, when you are ready to come onto your, aside from all the eligibility criteria that Danielle's outlined, how do you know in yourself that you're ready?
Well, I think it's when you answer that awkward question I just mentioned, when the client says, why can't you represent me? And you tell yourself, I know I can do a good job. I can go in and do that. You may have seen other advocates do it and you think I could do a better job than that. I think once you can answer that question in the positive, that's the time to do it. You don't need a wealth of experience because we take you through it. That's the whole point. We take you through it. And as I said earlier on, solicitors are qualifying with rights of audience, the same as you will have, but you are better prepared than the training that they get.
Yeah, absolutely. And you're right. I always found that a very difficult conversation to have at the police station, particularly with youths, because you would really have to work to build up that trust with them. And some of them were in local authority care, being shoved from pillar to post, and you felt awful saying, and now I'm going to pass you on to someone else to represent you in court tomorrow. So I agree with you. It was very I felt great when I could say to them, well, actually, you're going to see me again tomorrow at court and I'm going to help you, so don't worry. We've got one other question about that. So do criminal rights extend to appearing to represent sentencing in Crown Court from the Magistrates Court on a committal?
Well, the committals don't exist anymore. They were abolished a couple of years ago. But if you have rights of audience to conduct a case in the Magistrates Court, and there is a conviction, as long as you've handled that case in the Magistrates Court, you have the rights of audience to handle either the sentencing, if it's committed for sentence. I thought not committal for trial. If it's committed for sentence, then you have the rights of audience to deal with that sentencing hearing in the Crown Court. Of course, if you've handled the trial in the Magistrates Court, you also have the right to appear if there's an appeal.
Yeah.
So you can actually be appearing before the Crown Court judge.
Great. Okay. I'm just looking for a few more questions. Would you recommend doing the course just for the knowledge and experience? I don't envisage needing the qualification, but it sounds like it would be helpful for representing clients at quasi-judicial hearings. That's a really good question.
Well, it's a very simple answer, yes. I think it will equip you for any type of hearing, frankly. And that's why I highlighted that trial strategy planning that we do, because it really enables you to handle just about anything, because it's an in-depth analysis. Many experienced advocates who handle trials quite comfortably, they've come on CPD course. I do a CPD course just on trial strategy planning, and they suddenly think, why did I know this 20 years ago? It totally gives you the confidence and the competence to handle anything. So yes, just acquiring the knowledge, even if you don't want to do the assessment. But as you've done it, why wouldn't you?
Yeah, and negotiating skills, of course, are good for all sorts of business. So
well, I constantly say advocacy isn't limited to the courtroom.
Yeah, I agree with you. I just want to ask you one on family, because we've had quite a few members say that they're interested in the family, getting the family advocacy rights. So how does the family course work if you solely do public law work? Will I also have to do private law areas such as private law children, even though I only work in public law care cases? Yeah,
it's a good question. We've had a number of delegates in the past who work for local authorities and so on, and they're doing predominantly public care work. But yes, there is an element of private work within the course and within the assessment. But it's still equipping you to handle those advocacy rights. It gives you that competency. So yeah, there's a bit of both on the course, and there's a bit of both in the assessment.
Okay, and are you able to take any materials into the written assessment with you? I like this question, thinking ahead.
Well, yes, it's a partial open book. You can take quite a lot of information in with you, and you may say, well, we're doing it online, I can have whatever I want in front of me. Well, we make you scan what you have in front of you before that assessment takes place, the written assessment takes place. But yes, you can. It's partially open book, but I always give a cautious warning. This is a 75-minute exam, the written exam. And a danger is you may think if you have a lot of reference works with you, it's a comfort blanket. It might be a comfort blanket that strangles you because you'll want to look something up for a question that may only be worth a couple of points or a couple of percent, and you get drawn in. And suddenly you spend 10 or 15 minutes for something that's going to get you 2%. So yes, clearly, yes, of course, you can take materials with you, and we explain what they are well in advance, so you know exactly what you can use. But we give you tips on how you should use those materials during the exam as well. For the practical assessment, as you would in court, you can have what you like in front of you.
Okay. So a couple more questions about how the online delivery works. So I remember when I did my course with you that I was video recorded, and at the time I thought that was absolutely horrendous and I was never going to get through that. But actually it really helped me to watch the recording back, and I thought, well, actually I look like I know what I'm doing and I don't look nervous at all, and that even gave me the confidence that I needed to think, well, even if I feel nervous inside, I obviously look fine, so I'll just get on with it. But do you record, now that you deliver online, do you record delegates' work that they complete online so they can watch it back?
Yes, we do. We don't record and play it back during the training session, but each day is fully recorded. At the end of the day, that recording is available, so they can look back at it, they can review it. And obviously, if they have issues or queries or whatever, we can pick them up the next day.
I think that's really valuable,
yeah.
I think, to the individual. And just one more about the delivery. So now that the course is online, does this give more flexibility when you can take the course?
Well, depends how many times we list the courses, I suppose. But yes, it does. It certainly gives flexibility in this respect. Normally, when we're doing them face-to-face, we do them at CILEx premises in Bedford. So people having to travel and so on and so forth, and they need to fit those in with wherever their other commitments may be. Online does give us a greater flexibility as to when we can list those courses, because we don't need to have the accommodation, physical accommodation available. And having said that, of course, that's the other benefit of doing it online. It is economically better because you're not having traveling costs, you don't have accommodation costs, you're not away from home, or when we're back in the office, you're not away from the office. It's beneficial all around.
Yeah.
Yes, I think is the answer.
Yes. So dependent on demand, you shall aim to meet the demand, I guess.
The greater the demand, the greater the number of courses we'll run. Yeah.
Yeah. Excellent. I don't know if this might be one for Danielle and yourself, but there's a question: will I need to undertake the client care and research skills course before I make my application if they were not a requirement when I qualified?
Not under this scheme, no. So the knowledge requirements just focus on the matched law and practice paper at level 6. So if you didn't have to do them when you qualified, you're already qualified presumably, so you'd be absolutely fine.
Yeah, and there's one, why is it I must be a fellow to have advocacy rights? I think I'm guessing it's because you need to be a qualified lawyer before you can take that extra step to apply to be authorised as an advocate. Have I got that right, Danielle?
That's right, yeah. It's just built into the rules that only chartered legal executives can be authorised as advocates. So unfortunately, that's just how it is.
Can I add to that as well? Because what we find, having reached that level, the delegates that come on the course have specialised in their area of work, they're experienced in that area of work, and frankly, they are so much better. I've got to say, it's so much better than the solicitors I train, to be honest, and that adds to why you're better prepared when you get the qualification.
Yeah. So I think we've gone through most of the questions. There's one final question, which even if you can't answer this now, Roy, we'll aim to answer when we send out the slides. But is the next course date now confirmed? They haven't said whether that would be for crime, civil or family, but if you haven't got any scheduled, I'm sure there will be some dates coming up from what you've said, and we'll aim to provide those dates to the members that have registered for this webinar today as soon as we can.
If you asked me that on Monday, I could answer it, I think, with a yes. I believe CILEx are waiting for the LSB just to sign off on it, and I'm told that's going to happen within 48 hours.
Today.
Oh, it's happened. There we are.
So the next criminal course is running the 13th of July.
Yep.
So it might be a bit tight for anyone new then, but you can always give it a go. And the family and civil courses will be later in the year.
Yeah, and we have, if, as I say, if there's a generation of demand for more courses, being online, we can fit them in.
Yeah. Okay. Well, thank you both for joining us today. I think, I mean, I've taken away a lot. It's almost acted like a refresher for me because I've not been in court for a while. So thank you for that, Roy. And hopefully all the members that have joined us today will now go away thinking, well, they're equipped with all the information that they need. One final message from me is that I hope we've given you the confidence to do this, because I know that for some time before I became authorised, I was thinking about doing it for ages, and I just needed that push to just sign up and do it. So, you know, if I can do it, and I really loved it, I loved the experience, I loved going on the course, and I often think about it, thinking, you know, how great it was and how much I got from it. So you won't regret it. And just go for it, I say. But have a lovely weekend, everyone. And as I said, we'll be circulating the slides after the webinar, and it has been recorded today, so we'll add it to My Career, which you can access via your My CILEx accounts. It will appear on there in about a week's time, so you'll be able to watch it back if you want to. And that's all from us. So have a great weekend, everyone. Thank you. Goodbye.
Bye.